In a significant development in the litigation surrounding India's worst industrial disaster, the Bhopal Gas tragedy, Attorney General for India R. Venkataramani today informed a constitution bench of the Supreme Court that the central government was keen to pursue the curative petition filed against Union Carbide Corporation, which is now known as Dow Chemicals, seeking additional compensation to the victims of the Bhopal Gas tragedy. In 1984, the gas leak at the Union Carbide plant in Bhopal killed nearly 4,000, leaving generations thereafter reeling under the harmful effects of the methyl isocyanide gas. In close to 20 years of litigation, the case has seen a lot of twists and turns. The development comes 12 years after the Indian government filed a curative plea seeking additional compensation from Union Carbide Corporation, which ran the Bhopal gas plant. Back in 2010, the central government had filed a curative petition praying for inter alia rupees 7,844 crores in excess of the settlement amount already disbursed by the Union Carbide, contending that the settlement was based on incorrect assumptions about the quantum of deaths, injuries sustained and the losses incurred. 12 years after the issue was agitated, the Supreme Court is set to make a final pronouncement and give, as the presiding judge, Justice S.K. Kaul puts it, quietus to this matter. The 5-judge bench of the Supreme Court, which is hearing the case, also comprises Justices Sanjeev Khanna, A.S. Oka, Vikram Nath and J.K. Maheshwari. On the previous hearing date, the bench had asked the centre if it was intending to pursue this particular curative petition. The Attorney General today informed the bench of the willingness of the central government to press the petition and requested to be granted some time for preparation in this matter. According to the central government, the earlier settlement had not taken into consideration the subsequent environmental degradation that occurred. The settlement was also based on the earlier figure of 3,000 deaths and 70,000 cases of injury, when as many as 5,295 people had lost their lives and 5,27,894 had sustained grave injuries. A massive public outrage had come on the heels of the controversial settlement brokered between the Union of India, Union Carbide Corporation and the Union Carbide India Limited. In response, the central government had filed the instant curative petition before the Supreme Court of India. However, this petition essentially lay dormant for more than a decade. The Dow Chemical Company, of which the Union Carbide Corporation is a wholly owned subsidiary, has accused the Union of India of attempting to renege on the settlement agreement and thus violating the rule of law. On the other hand, however, the victims and their families, as well as the non-governmental organizations representing them, have long maintained that the compensation paid by the delinquent companies was not commensurate with the harm caused to them. Advocate Karuna Nandi, appearing on behalf of the claimants in this matter, even accused the private corporation of playing fraud on the court. Nandi referred to an internal document which she claimed had details about how methyl isocyanide, the gas released from the pesticide plant in Bhopal, would lead to permanent injuries. Nandi also claimed during the hearing that despite the respondents possessing such knowledge, 98% of the claimants received damages only for temporary injuries and not for permanent injuries. She even said during the hearing today, and I quote here, "The victims have to be given an opportunity to be heard before this court comes to a conclusion." Now that the Attorney General has made such a heartening statement, we are hopeful that we will be given due regard. The counsel for the respondents, among which were senior advocates Siddharth Luthra as well as Ravindra Srivastav, however, strenuously argued today inter alia that the curative petition was not maintainable and that the non-government organizations as well as other parties have no locus standi to be impleaded as parties. After hearing the submissions advanced today, Justice Kaul said that the matter will be taken up for hearing again on January 10th next year and that one day will be reserved for housekeeping in order to ensure that all documents and everything else is in order. The parties were also ordered to prepare a joint compilation within a period of 8 weeks. Thank you. I'm Aratrika Bhomik for LiveLaw. Keep watching LiveLaw for more such updates.